morning?
Chairman Conyers, Ranking Member Smith, members of the committee, thank you for the invitation to testify this morning. Our constitutional system of checks and balances assumes a certain jostling between the President and Congress, but the Bush administration's refusal to provide information to Congress and to the American people, the Bush administration's insistence on acting in secret, is more dangerous and more sinister than just an extravagantly ambitious claim to executive branch powers. Control of information stifles dissent. It insulates an administration from challenge, either by Congress or by critics. Control of information is incompatible with democracy. Informed criticism, as annoying as it frequently is to people with power, is the stuff of democracy. Democracy dies behind closed doors. It is Congress's duty to throw the doors open and keep them open in future administrations, Democratic and Republican alike. A great American political scientist, Woodrow Wilson, said that it is the proper duty of Congress to look into every affair of government and to talk much about what it sees. It is meant to be the eyes and the voice to embody the wisdom and will of its constituents. The many disputes between Congress and the President, and it is not just Myers and Bolton and Rove. Every committee has been stiff-armed by the Bush administration in our exercise of our oversight powers. Those disputes will not be resolved before the election in November or by the inauguration in January, but those disputes will not be moot next year. We must continue our effort to learn how the Bush administration has used the powers of government, and we must restore the balance of powers between Congress and the President, regardless of who is President and regardless of which party is in the majority in Congress. I have introduced one bill just last week to restore Congress's checks on presidential power, especially the power to act in impregnable secrecy, and I expect to introduce another shortly. Ms. Lofgren asked for practical suggestions on how to right the balance between the branches of government, how to restore the separation of powers and the checks and balances that the founders of this republic intended, and that has been my aim. The first bill, H.R. 6508, Chairman Conyers is the co-sponsor, Mr. Nadler is as well as Ms. Sanchez, and obviously I'd welcome additional supporters. Will allow the House to ask court appoint a special prosecutor for a criminal contempt of Congress charge where the United States Attorney refuses to present the case to the grand jury. In recent history, Congress has enforced our authority to take evidence by referring contempt charges to the U.S. Attorney under a 1857 criminal statute. There is not a lot of wiggle room in the language of the statute. The House and the Senate may submit contempt charges to the U.S. Attorney, whose duty it shall be to bring the matter before the grand jury for its action. Despite that unequivocal statutory requirement, when Congress referred criminal contempt charges against Josh Bolton and Harriet Myers, Attorney General Mukasey refused to allow the U.S. Attorney to present the charges to the grand jury. He argued that criminal prosecution is exclusively an executive branch power, and Congress cannot compel the executive branch to bring a criminal prosecution regardless of what the statute said. In a 1987 decision, the Supreme Court held that a trial court could appoint a private prosecutor to bring a contempt of court proceeding where the appropriate prosecuting authority denied the court's request to prosecute. The Supreme Court held that a trial court's power to appoint a private prosecutor was based on the trial court's inherent power of self-protection. If the judiciary were completely dependent on the executive branch to redress direct affronts to its authority, the Supreme Court said, it would be powerless to protect itself if that branch declined prosecution. Congress cannot depend entirely on the executive branch to redress direct affronts to Congress's authority any more than the courts can, especially when the affront is by the executive branch itself. Second, the U.S. Justice Department's Office of Legal Counsel is little known to the general public, but it exercises remarkable power. The Bush administration has fully realized the potential for the abuse of the OLC's power. The Bush administration has, instead of seeking disinterested legal opinions from the OLC, the Bush administration has demanded and gotten exactly the opinions from the OLC that it wanted. And the Bush administration has received those opinions and acted on those opinions in secret, placing the opinions beyond any challenge. Even when the OLC obligingly advised the Bush administration that the Bush administration could just ignore the requirements of statute. The Bush administration asserts no exigent circumstances, no practical necessity for that breathtaking claim of power by the OLC, that they can exercise in secret that legal power. It is simply a calculated expansion of presidential power at the expense of Congress and the courts. I'm now working with Senator Feingold and with others on legislation to require the OLC to report opinions to Congress, especially where the OLC decides that the executive branch can just ignore statutory requirements. James Madison wrote, "The founders of our republic provided against the usurpation of power by providing each branch of government the necessary constitutional means and personal motives to resist encroachment of the others." Madison wrote that the constant aim is to divide and arrange the several branches in such a manner as that each may be a check on the other, that the private interest of every individual may be a sentinel of public rights. The Bush administration's claim that the president alone decides in his own unreviewable discretion to tell Congress and the American people is an encroachment that we must resist. And by jealously asserting our rights under the Constitution, we defend the public rights. Thank you.